Hi guys, welcome back to the channel, The Journey. Well, Bionca Ellis. Now she's had many trials, not many trials, but she's had many hearings. And Wednesday, jury selection began. Now very late today, opening arguments. Day one. So tomorrow will be day two of the trial. Now, Bionca looks a little, insane. If you watched her other hearings when she was arrested, yeah. But in the end, Ellis has pleaded not guilty by reason of insanity. Yep. I wonder why. I wonder why. Now, like I said, the jury selection wrapped up today and also started late. And she has been charged with killing a little 3-year-old boy by stabbing him outside a grocery store. Also stabbing the mother. Now the little 3-year-old died from his injuries. Now, Bionca Ellis is 34, of Cleveland, Ohio, faces 10 counts, including aggravated murder and the death of the 3-year-old Julian Wood, and this was in June 2024. And also faces assault charges for attacking the mother. Allegedly, because, we are in a trial. So that was just a little intro to what this is about. My God. Only a year ago, and I didn't think this was going to get to trial, but I don't even know if she really is faking. What do you think? Hey, Rubber, have you heard of this one? It happened last year. Oh, yeah, this one's a bit cuckoo, cuckoo. I think it took the jury, not the jury, but jury selection, quite a while. Started last Wednesday, finished up today. Yeah. I think they were very careful on picking the jury to do with mental health. Yeah. You have no clue. Oh, God. You should refresh yourself with some recaps and then you'll understand. I'm just going to do a little recap right now because the trial has started and I didn't even think it would get to trial, let alone this soon. I can't even believe it. I can't believe it. Now, this hearing just happened a few days ago, so it was one of her last hearings. So we'll start from there. Her last hearing before the trial started today. Here we go.
All right, so we're on the record this morning, case 692604, State of Ohio versus Bionca Ellis. Good morning, Miss Ellis. We're here this morning just for our final pretrial. This case is set for trial on Wednesday. A couple motions that are pending with respect to the trial that I'm going to ask parties to discuss.
Thank you, Rubber.
Before we do that, I just want to make sure I just go through some logistics.
I like that
we
picture.
Spoke about so that we're all on the same page. So, Ms. Faralia, thank you for being here because I know you're currently in trial. The expectation is that we all think that you'll complete your trial maybe Tuesday, but for sure we give you the day of Wednesday. The trial here is to start on Wednesday, but in fact, we had put that in our calendar for really a questionnaire of the jurors. So if I can have you on Wednesday morning just to greet the jurors with my opening comments before they fill out the questionnaire. I think we all agree the questionnaire will be completed. Those 70 jurors will be excused for the day, and we'll reconvene on Thursday with all 70 jurors being here. We'll only bring 40 up initially and begin our voir dire and our questioning of those 40 jurors, and that's how we'll begin on Thursday. We are off on Friday, and then we'll continue to voir dire the jury until we have one impaneled. I did mention to all of you that I'll have 16 jurors, so I'll have 4 alternates as well with respect to the case. The courtroom's a little tight, but I think I know there are 2 different thoughts process of how we should conduct a voir dire, but I'm comfortable with this being in the courtroom the way it is. It may be that I may be able to move some tables a little bit further back if you think it's too close, but I'll try to do that adjustment with the sheriff and my staff today as well. And then finally, with respect to the trial, we're going to move forward, in a fashion that's timely. Of course, my job, Ms. Ellis, is to protect the constitutional rights regarding the trial, and so that's my job, and I'm going to continue to do that. All of you proposed a questionnaire to me, and I've modified that questionnaire, and we talked a little bit about that. I'll ask Kathleen to make sure that that's provided to you this morning with the modifications that I suggested. And I'd ask by the end of today that you give some thumbs up or some suggestions, and I'll make my final changes to that questionnaire and provide that. Again, we'll be handling matters on the 12th floor. Again, we'll do that outside of the public view regarding this jury and the questionnaires and those questions as well. And then with respect to the let me ask, anything further with respect to those discussions that we talked about, anything from the state of Ohio? And I'll note for the record that Ms. Pateo and Ms. Faralia are here, but also Mr. Miranda has joined the table, Anthony Miranda for the state. And counsel are present, Mr. Mack and Mr. Johnson for Ms. Ellis. But just regarding the jury, anything that I may have missed, Ms. Faralia, regarding our discussions in chambers?
No, Your Honor, and thank you for the courtesy.
Okay, thank you.
Concluding either tomorrow evening or Wednesday morning.
Very good, thank you. Mr. Mack, anything I may have missed?
Nothing further.
Okay, thank you. All right, so then let's go to the 2 motions. So let's go to the motion first, just to hear arguments, and I'll take it under advisement, is the motion to sequester the jury during the trial. Mr. Mack.
Judge, on behalf of Ms. Ellis, this is a high-profile case with significant media coverage, and we requested that you sequester the jury throughout the entire trial. And we want to ensure that Ms. Ellis receives a fair trial and making sure that there's no outside influence to taint the jury. We want to make sure that jurors are protected from threats and tampering. We want to make sure that the decision is based solely on the evidence that comes out of this courtroom, rather than what they see through social media, rather than what they see through the coverage of this case. I've tried a number of cases in your courtroom. This is the first time I've ever asked to sequester a jury. And you don't need me to say it. Exhibit A is right here in your jury box right now. This case has had the kind of exposure that I believe is necessary to protect the defendant pursuant to the Sixth Amendment of the Constitution. Juror safety is important, but the integrity of the process is what is most important. No matter what she's charged with, she deserves a fair trial. Now, I understand that there's a burden financially that comes with this. I understand that there's a burden by any juror that undertakes this and want to be a part of this process. But there are other cases that have had jurors sequestered for far longer than what we're asking. We believe that the case should last a week, maybe a little more, I'm not sure, depending on how many witnesses get paired now. But the financial burden and the burden to each individual juror does not outweigh the fairness and the integrity of the process for her. So I've asked that you do it. You have the authority to do it pursuant to Ohio Criminal Rule 24H. And I think it's a reasonable request in these circumstances. Once the jurors have been impaneled, and if you don't do this, then you've lost control to manage what may be coverage through social media and other outlets. Thank you.
Thank you. On behalf of the state?
Thank you, Your Honor. May it please the court. The state recognizes that the court has discretion with respect to sequestering. Sequestering at the beginning of the case is very unusual in this county. It's appropriate to guard against improper media or media improperly influencing jurors, but there are standard jury instructions that the court can provide the jury to guard against any risk that they're improperly listening to media or social media. Sequestering at the start of this case would cause a substantial inconvenience to the jurors who have family outside of this case. So for that reason, we would ask the court to deny the motion.
All right, thank you. Anything further?
Just, Judge, I don't think that unusual is the litmus test. I mean, it's not the test. And instruction is given in the beginning of a case, but you don't know what folks are going to do once they're home, once they're around their family, around people that they trust. And inconvenience certainly is not the standard. So there's a reason why you have a discretion that you should employ it.
Yeah, but look where she
All
is
right,
now.
thank you. All right, I'll take the matter under consideration and I'll have a ruling before the end of the day here. With respect to the second motion, I know we had some further discussions and I've had an opportunity to review some of the evidence that may come in or at least may be presented by the state. That second motion was a motion in limine to exclude irrelevant, repetitive, and unfairly prejudicial photographs. And so, Mr. Johnson, why don't I hear from you?
Your Honor, Mr. Court, I believe it came as we had opportunity to get some access to what we wanted to see, and I think we probably have a stipulation that will pare down a lot of the unnecessary photos, even though they might be inflammatory or prejudicial for the required state.
All right, and so we'll note, Ms. Bralia, that when looking through, I think the autopsy photos, we've narrowed those from 200 plus to 9, and I've had a chance to review those as well. And is that acceptable to the state?
Yeah, sure, there's actually 10. And in addition to what Mr. Johnson indicated, there also will be some crime scene photographs, drone footage, and videos from different parts of the day prior to the homicide and then after the homicide. But all of those will be shared with the defense prior to the commencement of trial if possible. And as standard, once a trial begins and something needs to be shown, that's always shared with the defense. And if they have an objection, then you, being the arbiter of the law, make that determination.
Yes, and so at this time, let's start the trial, in a fashion that evidence will be presented. If there's an argument to be made, we can have that argument at sidebar. I'll make a decision during the trial as well. All right, I appreciate your ability to have those open communications, and thank you for doing that as well. So let's go then just some final thoughts. I have signed and executed a media order. And so in the courtroom today, we'll just have one pool camera that'll be in the corner, as opposed to, of course, a number of cameras being in here. It will not interfere with you and your production as lawyers. There's a number of things that the camera crew cannot do, like recording conversations or recording sidebar. With respect to media and witnesses wanting to be excluded from video, I did specifically outline that procedure. I'm hoping it doesn't happen when I say, who's your next witness? And then you say, well, this witness doesn't want to be videotaped. So it needs to be something to provide me ahead of time so that I can actually have it on the record without the jury being in the courtroom. And then I'll make a decision. And then I can instruct the camera pool on whether they're allowed or not allowed to video. Of course, jurors will not be videoed. And if a witness specifically has opted, and I grant that, I'll allow that to happen. But I want to be able to let media know ahead of time as opposed to spontaneous in the courtroom. So if you can be mindful of that, I appreciate that as well. And then in and out privileges, I did discuss as well. We're not going to allow that movement in and out. There'll be some precautionary means of coming in and out of the courtroom as well that the sheriff has put together for me. And then lastly, I wanted to note that the parties have had discussions at my request about whether there was a potential opportunity of resolving the matter. And I think all of you have had those diligent discussions back and forth. But Ms. Faralia, just for the record, before we begin on Wednesday, there's no mark on the file as far as an offer being made as far as a result to this case. Is that correct?
That is correct, Your Honor. Nothing has been offered at this time.
Okay. But fair to say there have been discussions between the state and Mr. Mack and Mr. Johnson.
That is fair, Your Honor.
Yeah, thank you. And anything to add to that, Mr. Johnson or Mr. Mack?
Judge, in all fairness, we haven't asked for anything.
Very good. All right, thank you. And then lastly, from the state, anything before we recess for the day? Otherwise, I think if you are still in trial, Ms. Faralia, the judge is going to give you a chance to at least meet the jury when I bring them down on for the beginning of the questionnaires. So I would see you on Wednesday morning. But anything further that you would want to address with me?
Not at this time, Your Honor. Thank you.
Yeah, thank you. And again, just whoever's going to follow up with my bailiff regarding the questionnaire that I finalized today as well. And then Mr. Johnson, Mr. Mack, anything I may have missed or anything you want to address before we recess?
Not before we recess.
All right, very good.
Thank you.
All right, thanks, everybody. We'll adjourn.
So that's what happens. We'll just watch this by this visual. When she got arrested outside the store, Now, I think, you know, they said, oh, well, you know, she'd be all right if she was amongst family and everything. Now, look where she is now. Excuse me? No, she won't. You're not going to let her out. Hell no. Look what she did when she's supposed to be being kept an eye on by family. Schizophrenia, offer medication. And this is why she pled not guilty by insanity. Well, the thing is, how does she know if she was off her medications? How did she know that she's insane? Because she didn't take her medication. She stole the knife from a thrift store, walked out of a thrift store. Mind you, she probably could have got a knife in that store too, but they said that's where she stole it from. People in the store, she's walking around swinging a big carving knife and nobody says nothing? What would you do? What would you do if you see somebody wielding a knife and looking a little crazy? You're going to alert somebody or you're going to call the police? But first of all, you're going to alert somebody in the store. You're going to ask them to get the manager and get some security there, right? Yeah. Okay. Everybody's walking around just minding their own damn business. You know, either too busy on their phones or doing what? I don't know. You know, this could have been avoided. It could have been. If people would just paid a little attention, acted faster, you know, thinking, this ain't right, this ain't right. What the hell is she doing with a knife, walking around with a knife? That's not right. Your first instinct will say, ew, that ain't right, right? Walking around like a mad lady. But anyway, this is just a little recap. I just put some music on because I don't want the, let's put the volume up a little bit.
You have no reason? You just want to? Okay, so I'm just going to go through the formality, right? So they want you to leave the property. They want you to, you know, leave, not come back. I'm trespassing you. You're being formally trespassed by the Osceola County Sheriff's Office. You need to leave the property now.
But what about getting arrested?
This happened the day before, I
Are you refusing
think.
to leave the property?
Yeah.
Why?
Because it's cold outside. I don't know where to go.
So you're just refusing to leave the property?
So she got family,
You
she's
have no family,
homeless.
no nothing.
No, I'm not from here. I was just vacation.
See, she talking normal there.
Stand up.
Uh-huh.
You guys gonna take my stuff too?
Turn around.
Shove her medications there.
What's going on with this stuff? This is weird.
Gotta really take a good look at her
Can you move your
because
thumb out of the way?
she follows orders.
Trying not to get the fabric pinched in there.
Now, if somebody's responsible for her well-being, make sure she takes her medication each day, they weren't doing a very good job, were
Let's
they?
face each other. There you go. Anything on you I should be aware of? No drugs, no guns, knives, nothing. Would you be more comfortable with 2 cuffs? Huh?
During her arrest, Ellis appeared stone-faced, but another deputy's body cam captures Ellis asking if she can use the phone when she gets to jail.
Uh-huh. See what I mean?
Drugs, guns, knives, bazookas.
Will you guys let me use the phone when I get there?
At the jail you do.
Okay, thank you.
You can also get phone numbers out of your phone. So you have to use the jail phone, but they let you get phone numbers.
Okay.
See? She answers, follows orders, answers simple questions. She knows she's being arrested and handcuffed, and she needs a support bra or something, you know,
Both of those are mine.
lift and separate or something. But if you ask me, it just gets
She was then
worse.
taken to the back of a squad car.
10:15, one black female. Got this beat up white car over here. Walk around the passenger side. Is there anything in the
Shuffle,
pockets?
shuffle.
No, like nothing. I'm gonna search this pocket here.
She's getting irritated now. Too many questions, man.
You guys want to get my personal ID?
He don't really want to search her because he's a man.
Big seat in the car.
Her boobs are too.
Thank you much.
The deputy then
I think
made
her boobs
belongings.
down to her knees, I think. For such a 34-year-old, you know, such young
Clothes, lotion,
to
and
be
more.
like that.
The deputy informed her all of those items won't be able to go to jail with her.
The jail's not gonna take all that. So what do you want to go to the sheriff's office?
What do you mean?
I mean, the jail's not gonna take all that. You can only bring a certain amount of stuff to the jail. I'll put the rest of it at the sheriff's office for safekeeping.
And then I can go and get it?
You can go get it later, yeah.
Okay.
You want to bring anything with you?
My purse, the pink one.
The little pink bag?
Yeah.
You want all your cards and stuff that were in it to
Yeah.
stay in it?
Uh-huh.
Anything else from the other bags?
No.
Okay, so the other bags will go to the sheriff's
You
office
see?
for safekeeping. Keep things.
See how she answers?
And we can't keep liquids and stuff.
How about food and liquid again?
Like some little bottles of things.
Lotion
Yeah, you can't have that stuff.
at the sheriff?
To be competent, you only have to answer basic questions, understand yes and no,
They're gonna be disposed of.
follow some orders. That's it. And you're competent.
Transported to lockup.
All right, over that open door.
I think she likes going to jail. I don't know how many times she's been there. Scuffle, scuffle.
Face the wall. One meal,
Look at her.
lunch.
I'm sure she's got some medical issues, but the thing is,
You're not gonna run away, right?
somebody has to make sure she takes her medication every day on time,
Fit around your clothing.
and nobody's doing that.
You can put your leg down.
She just takes off and goes elsewhere. They're supposed to be calling somebody. Because she certainly is a danger to herself and others.
All right,
Can you listen to someone?
this one.
Now, I hope she don't act out, you know, like Shabazz-ness. Because, you know, Shabazz-ness went a bit crazy.
I mean, there's plenty of room. They're just not very comfortable right now. Just take a seat.
Oh my God.
It wasn't known at the time, but just months later, Ellis would be back locked up in her home state of Ohio, accused of a horrific murder. Ellis spent more than a month locked up in Florida, but was eventually released on April 30th, just a month prior to the stabbing of 3-year-old Julian Wood.
You see
Prior
what I
to the
mean?
attack on June 3rd, Ellis exhibited seemingly bizarre behavior. On the day of the stabbing, Ellis was seen walking into the North Olmsted Police Department, pushing her own wheelchair with a suitcase. Authorities say she was there in connection to her arrest the week before, which was related to a previous theft offense, where she was arrested 4 days prior to the stabbing at Giant Eagle. However, she was let go from custody.
And they
After
didn't
leaving the police station,
do a
surveillance
thing.
video captured Ellis outside of a local thrift store in North Olmsted.
Not like a hold, a 72 hold, a medical evaluation. What meds are you on? Are you taking up? Nothing. Look at her with the knife. Look at her with the knife. She's coming out of the thrift store.
Allegedly stole 2 knives, one
Look
of
at
which was used in the deadly attack. According to investigators, after
Tap,
leaving the
tap.
thrift store, she walked over to Giant Eagle. A surveillance video obtained by station WKYC shows Ellis inside the store, holding the knife out in the open. It was inside the grocery store where Ellis spotted
Nobody
the
takes
man
no
with a
notice.
and then followed them out to the parking lot and attacked them before fleeing the parking lot on foot. Body cam video from the heartbreaking day captured the chaotic scene as officers rushed to the grocery store and emergency crews worked tirelessly to save the toddler's life.
5212, I'm behind medic 51, we're pulling it a lot.
The thing is, nobody did nothing. Nobody put her in a hospital, put her a 72 hold, you know, get her some medical help. That don't seem to have been done. Whose fault is it? I don't know.
Squad's going up now. Squad's going up now.
A short while later, another officer's body cam shows Julian's father and Margot's husband arriving to the heartbreaking scene.
Heartbreaking. You know, all these people walking around, nobody did nothing until, you know. So many people yet. Nobody. Not really.
Is that your son? Yes. Okay, come here. We're gonna have somebody take you to the hospital. All right? Okay, we're gonna have you take you to the hospital.
I'm parked over there. Yo, you leave your car.
Where's your keys at?
I have my keys right here.
Where's your car?
It's the truck that's parked facing this way. I'm taking him.
Yeah, I'll be right there. I'll get your keys.
My
Don't worry
God.
about it.
What would you do if somebody's attacking somebody with a big carving knife? What would you do if it was just that? Well, you get some out of your vehicle, somewhat hard, like a, I don't know, something that you blow your tires up with air. They got a attachment, a little handle. It's hard as rock, okay? Won't break, won't bend. Whack. Yeah, I'll be reaching for that. I just whack them anywhere that I put them down. Of course, I don't have a pow-pow, you know. But if I did, I might use that. But
Just tell me what I need to do to help, buddy.
you just got to think about these things. What would you do? Be prepared and know where your tool is. So I say. It just brings a little light to what could happen. Oh my God, that poor little boy. I mean, I think that stab to his neck did him. I mean, the one to his back could have done it too, but I mean, he's only 3 years old, a little boy. Nothing to him. You know, this mother was just walking with her baby, just went shopping, just walked along, sitting there, and along comes her, Ellis. Stabbing away, Miss Stabby.
One witness told the officers the alleged murderer didn't say a word before coming up behind Margot and Julian Wood.
Look at her.
Attacking them.
That was her first attorney. She don't have that woman no more.
Did she say anything? No, I didn't hear anything. I had my windows. I didn't hear anything. All I heard was just screaming, and the lady grabbed her child up out the cart, and that's when it fell over. The lady collapsed over here, and the lady just continued to walk off, and that's when everybody just kind of came out of nowhere.
And the lady,
And I got out. One guy, he said, "What happened?"
the attacker, you mean?
I came about halfway, and I saw her trying to get away, so I hopped in the car and chased her down. Okay. To almost where that white building.
Yeah, it is wow.
That's when I called
Rubber.
911, and like literally 30 seconds later, you guys showed up. Okay. All right, cool.
Just because you don't take your psycho medication, don't mean you're gonna get away with this kind of
Emergency responders rushed to try to save Julian's life.
behavior.
National officers were on the hunt for Ellis.
It's known, it's been put through the law. If you don't take your medication and you commit a crime like this or any crime, expect to take your punishment because it's going to be no excuse, right? If you're that bad off, then you should go to the psych ward and stay there and never release until whenever, right? People say, yeah, I'll watch out for them. I'm the carer, and they don't do it. They don't do it. Right. There's no excuse anymore. You will be accountable for your actions. Anyway, she does know what she's doing. She does answer questions. She does follow orders. But today she's looking, you know, how much is fake? Because she's psycho. Schizophrenia. Just because you're schizo, it could be managed by medication. Lots of people live normal lives being that. Schizophrenia, yes, they live a normal life. Nah, no, they're not. And they try not to even put people in them anymore. Oh, just go to jail instead now. Go to prison instead.
According to authorities, Margot Wood was stabbed in the shoulder.
But knowing what was going on days before, and nobody did nothing. Nobody checked her out, got her on a 72 hold, did some medical checks, make sure she's taking her medication, get her back on them if she's missed them, you know, where she lived. Nobody did nothing, right? Just let her go.
Attempted murder, felonious assault, tampering with evidence, and theft. During her initial court hearing held on June 10th, Ellis was seen smiling several times as the judge discussed her case. Julian's father and Margot's husband appeared in that court hearing as he emotionally asked the judge to keep Ellis behind bars. He would say in court, "That day 1 week ago, she took everything from us. There's nothing that could ever replace my son or anything that my wife and I, even our other kids, are going through. It's horrendous. I really wish no bail, period, or extend it to the maximum limit possible that you can at the very least. Just do whatever you can to keep this monster behind bars." And there's seemingly no chance she does get out of jail, as the judge ordered she be held on a $5 million bond. Online record.
Yeah. She held on a $5 million bond. That's pretty hefty. Pretty hefty. So, when she was arrested, I think this was her first court appearance. I think so. I think this was the first. Yeah. Okay. This was her first court appearance. And might be her first one, and then she also comes into court. Let's get to it.
Good morning, Your Honor. Ashlyn Carroll on behalf of Ms. Ellis. We would
Excuse
like.
me, I'm going to ask her the questions.
Oh, sure.
Ms. Ellis? Ms.
I'm
Ellis?
going to ask the questions. That's
Ms.
the
Ellis?
judge.
Yeah,
Please raise your head.
where is it coming from?
I just need to ask you a few questions. I need to make sure you understand them.
Who's
Do you have an
there?
attorney?
Where's that voice coming from?
Okay. Do you have the money or means to hire an attorney?
Repeat that.
Hello?
Do you have the money or means to hire an attorney?
Possible.
Okay. Have you received and read your indictment?
I don't know.
You don't know if you've received it? Have you received it? Ma'am, just tell me whether or not you've received it, please. Ms. Ellis, we'll be out of here in a few minutes if you just answer these questions.
What do you think?
Ms. Ellis,
She goes from one extreme to
have
the
you
other,
received your
don't she?
indictment?
What's her name? What's her name? The judge, what's the judge's name?
Russo,
Russo?
that's right.
Russo with an R?
Have you received and read your indictment?
See, she had the sense to ask, what's the judge's name?
Yes or no?
Mhm. And then she goes
If you
off
haven't received it, I'm going to send it over there.
somewhere
So you need
else.
to tell me that. Ms. Ellis,
Why don't you want to answer these questions? All right, we'll come back to it when she's ready to talk to me.
Your Honor, could I just let the court know our office does represent Ms. Ellis on another case, and
I understand.
there are some mental health issues, and I do believe they
I'll
have
come
been.
back to her.
Okay, just to clarify, I do believe she hasn't been on her
I will come
medication.
back to her.
Okay.
That judge, she's like,
Come back in the courtroom. Ellis.
she just took off. Get back there. Oh, yeah, this was at the beginning.
Ms. Ellis? Ms. Ellis,
Thank you.
have you received the indictment?
I don't know.
Would you like me to send it to you or read it out loud?
Thank you. Thank you.
That's not responsive. Would you like me to do either of those things? Ms. Ellis? Do you understand on the indictment that the state has reserved the right to add the death penalty? Do you understand that? Have you read that?
ASAP.
What's ASAP?
What's video for?
Your Honor, we would like to enter a not guilty plea for Ms. Ellis. We would like to waive a reading of the charges, waive any defects in time or manner of service. As I said, our office has reached out to the jail to get mental health services for Ms. Ellis. They were working with her on a previous case, and our social worker has gotten involved. So we would like to ask that counsel be appointed and that the public defender's office be one of those two attorneys, and ask for a reasonable bond.
Has she received the indictment? Have you discussed it with her?
I personally have not, but I do know attorneys from my office did go see her last week, and that there were some notable mental health issues.
Did they go with the indictment?
That I don't know.
Well, then how am I expected to arraign her?
I would like to waive that time period for her.
This could be a capital murder case. I don't think that's appropriate. So if somebody wants to go over there now and go over it with her, I'll hold it. So send somebody over there.
I'll reach out to the office.
Okay, we'll come back.
Ready, Your Honor?
I'm ready.
Going back to case number 692604, Bionca Ellis.
Hello, Ms. Ellis. Do you have an attorney? You do? Do you have the money or means to hire an attorney? Have you received your indictment? Okay, have you read it? You have not read it, okay? We have a copy here. You can read it. You don't want to read it. Are you willing to accept that the public defender has read it to you? I'm sorry. You asked her not to. Well, but she did read it to you, correct? No. She didn't read it to you. Okay, well, we can read it in open court. Okay. It's a 10-count indictment. Count 1 alleges that on or about June 3rd, 2024, the defendant did purposely and with prior calculation and design cause the death of JW 10/29/2020. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. And so you understand that means the state is reserving its right to add a death penalty specification. Count 2 alleges that on or about June 3rd, 2024, that the defendant did purposely cause the death of JW 10/29/2020. Count 3 alleges that on or about June 3rd, 2024, the defendant did cause the death of JW, date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit felonious assault, Ohio Revised Code Section 2903.11A1, and or endangering children in violation of Ohio Revised Code Section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to JW on date of birth 10/29/2020. Count 5 alleges that on or about June 3rd, 2024, the defendant did torture or cruelly abuse JW, date of birth 10/29/2020, a child under 18 years of age, and furthermore, the violation resulted in serious physical harm to JW, date of birth 10/29/2020. Count 6 alleges that on or about June 3rd, 2024, the defendant did attempt to purposely cause the death of Margot Wood. Count 7 alleges that on or about June 3rd, 2024, the defendant did attempt to cause the death of Margot Wood as a proximate result of the offender committing or attempting to commit an offense of violence if it is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2901.11A1. Count 8 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to Margot Wood. Count 9 alleges that on or about June 3rd, 2024, the defendant did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or
Listen,
investigation.
somebody
Count 10
should
alleges
have,
that on or about June
you know,
3rd,
invested in
2024,
a new
the
bra.
defendant did with purpose to deprive the
My
owner, volunteers
God,
of American
how
Sewer
low
of property
can
or
you
services,
go?
to wit, knives, knowingly obtain or exert control over either the
Come
property or
on.
services without the consent of the owner or the
Shut up.
person authorized to give consent.
98-year-old boots.
I have now
She's
read the
34.
indictment to you. Do you wish to enter a plea of not guilty?
See,
Pardon me?
see,
What's same mean? Yes or no?
yes.
Okay. I understand the victims are represented and they want to make a comment before I set bond. Is that true?
Yes, Your Honor.
Okay.
They make her face the other
Good
way.
morning, sir. Could you start with your name?
Oh
My
my
name's George
God.
Wood,
This is
father
heartbreaking.
of deceased, husband of Margot.
Oh my God.
Your Honor, that day, 1 week ago, she took everything from us. There's nothing
1
that
week
could ever
ago,
replace my son
when this
or
happened.
anything that my wife and I, or even our other kids, are going through. It's horrendous. I really wish no bail, period, or extend it to the
Certainly.
max limit possible by that you can, at the very least. Just do whatever you can to keep this monster behind bars.
Are you, Robert?
Thank you, sir. Is there anything else you would like to say?
That'll be it. Thank you, Your Honor.
Thank you.
Oh, Lordy. Oh my God. Look at her.
Your Honor, we would just ask that you consider assigning the public defender's office, recognizing this is not our number. We did represent her at the first appearance unit. I did meet with her on Friday. We have had contact with her family and begun working on the case. Thank you, Your Honor.
When the original bond was set out of Muni Court, the bond was set at
No,
$1
she
million.
go family.
And it was before the passing of one of the alleged victims. I do not believe that bond is appropriate given the change in circumstances and the allegations that are contained in this indictment. Bond is set at $5 million, cash, surety, or property. GPS, no contact with any surviving victim or victim's family, DNA order. Judge is John Russo, pretrial is June 17th at 9 a.m. I'll sign counsel.
Thank you, Your Honor.
Thank you, Your Honor.
You want me to sign that?
So that was a court appearance, you know, a week after the events. Yeah. He was the dad of the 3-year-old that she ended that little boy's life, Julian Wood. And the mother, I'm not sure where the mother was right there and then. She might be still in the hospital, I'm not sure. But yeah, they have other kids, but you know, you're just doing your grocery shopping, minding your own damn business. And somebody that's got mental illness, off their meds or whatever, not being taken care of, not being kept an eye on, you know, knowing how dangerous she could be. Yeah. God. Okay, my internet's gone a bit slow.
So.
This was another court hearing. It was about an hour long, but they would just sit there chit-chatting for most of that, okay?
What? Come on up here.
Really. I skipped forward. Yeah, they were just chit-chatting, you know, like you do. No, it's nothing to do with Ellis's child. No, I don't even think she's got children. But there's nothing to do with her. They were strangers. Oh, you were confused. Okay. Don't be like Ellis. No. I'll put you on your meds. No, but really. No, she was just, I thought, is she homeless or what? Because, you know, how can somebody be on medication for that condition, which is very serious, mental illness, and not be supervised kind of thing? You know, she had bags with her, looked like she lived on the street.
Hey, you got info, stick it in there. It only took 3 minutes.
Yeah, that's what they do. They just chit chat to each other. Okay, I'm going to skip that little bit. I thought I was there, but oh, I went to the beginning. I skipped that. I went too far. I didn't go far enough to where I wanted to start. Let's get it. Okay, here we are. Some reason I had it ready and it went back. Anyway, that's what they did. Chit chat for about 40 minutes live. Okay. Now here we are. Get down to business.
Just check your cell phones, please, folks. Turn on silent or vibrate. Actually, I won't play it.
Yeah, that's what they do, Rubber. They don't really put them anywhere no more. They just wait until they do something and then send them to prison. Let them put up with it. It's crazy. You see, now she looks a little different. Got her hair done.
692604. Ms. Ellis is present in the courtroom here this afternoon. Mr. Mack is here. I know Mr. Johnson is engaged in another courtroom, and we're going to excuse his presence today. Any objection to that, Mr. Mack?
No, you thank.
All right, thank you. And then Ms. Mateo and Ms. Farley are present here, assistant county prosecutors. I think sitting at the table also is possibly your detective on the case. I'll just let you know that for the record as well.
Thank you, Your Honor. This is Detective Sean Ventris from the North Homestead Police Department.
Very good, thank you. I first want to say to all of you, thank you for changing your calendars so quickly for me.
Yeah, probably because,
It's a personal matter for.
you know, they're going to put her on meds.
So thank you for allowing this to happen a day earlier. So we're set for trial on October 1st. I know that the parties have been pretty diligent, and I appreciate that as well with your calendars. And I know that as of today, I believe we have no conflicts. Are starting on Wednesday. There were some of you who have been double booked, well, not double booked, but booked by other judges. I think all those matters have been either resolved in a way that the judges have allowed this case to move forward in a way without having conflict. So I'm comfortable to say that October 1st, we'll start a trial regarding this matter. Regarding that, I'll note for the record that the motion was filed with respect to Ms. Ellis, that motion being filed on August 27th on her motion to enter a plea of not guilty by reason of insanity. The court is aware of that motion.
And they did
So
start
at this time,
last
the court's gonna
Wednesday.
proceed in a trial manner. I've asked for 75 jurors to be available that morning so that we can begin a jury process. I believe I've noted to the parties too that in a larger jury such as that, I like to do it on the 12th floor. I've done that recently on a civil case where I brought in a number of jurors. I believe I can fit 60 in the room. And so I'll accommodate 60 for that very first process. We'll have 15 available as we move forward if we need to bring additional jurors in. I will not allow the media for that portion of this case.
I wonder what she'd be wearing.
Confined area. So we'll do that on the 12th floor on October 1st. I've also asked the parties to my bailiff if you wanted to provide me with a jury questionnaire. That would be a brief questionnaire for the jurors that they can answer that might be revealing about their knowledge, if any, on this case, and then some other matters that we might want to address regarding the nature of the case, to see if then those documents can be provided to us and you to use in your voir dire of the jury. So I know that both of you are working on that. Ms. Faralia, Mr. Mack, I know maybe we've even had one on a different case, but are you working on that together, or do you want to provide samples to me and have me make that decision? Ms. Faralia?
Your Honor, Ms. Mateo and I have prepared a questionnaire. We have emailed it to defense counsel. They're going to be reviewing it. And once I think we can come to some type of agreement, if there's an issue, obviously it'll come before the court. But I believe that we can come to some decision with regards to some of the questions that need to be asked, answered by the jurors.
All right, very good. And I think on that morning, I'll have the jury commission, well, let me pause there, Mr. Mack, is that a fair statement? And then your thoughts as well.
Good.
Yeah, I'm sorry. And so that morning,
I don't know. They just throw it to the ground.
Pulled right after the introduction, so that I'll get them to the 11th floor, excuse me, the 12th floor, and allow them to fill out a questionnaire. We'll make copies of those and have those provided. And my guess would be that we would start having some discussions with the jury around 10 o'clock. Normally, I have that first interaction, which will, I think, give all the parties opportunities to review those questionnaires. If we need a little more time individually, I'll have that as well. And then finally, I'll just go to discovery. Is there anything that the state believes is outstanding or have not been conveyed to the defense, or is the state prepared to move forward with the trial on October 1st?
Your Honor, the state is.
Damn, that guy could type good. I wish I could type like that. I'm a one finger type.
Discovery that has been sent to defense. The state of Ohio has also inquired as some other documents that may be relevant in this case, and we are in our efforts. We have attempted to secure those records. I should have those by the end of this week, and those will be transferred to the defense as soon as I get my hands on that. Other than those particular documents that I have spoken to with Mr. Mack, there should not be any other discovery issues outstanding with regards to this case.
All right, thank you. Mr. Mack, I heard from you. Are there any concerns that you have?
Judge, I believe we're speaking of the same records that we discussed this morning, so it's not going to come on.
Okay, very good. And then Mr. Mack as well, I know I would ask that Ms. Ellis has the ability to not be in her in a provided clothing from the sheriff family, or you are not able, or she doesn't have clothing. I would ask that you just address my bailiff, and we can allow entry to be put on so that she can have that. In addition to that, if there's any
This is what I'm saying. Should do a tailor business on them.
You want, there has to be an order for me to tell the sheriff. So I would just ask that whatever it might be, that you let my bailiff know, and then we'll make sure we put it in together.
Yes, sir. Thank you.
Very good. And then lastly, just to plan, at least witness-wise, I would hope that we would have a jury impaneled by the second day, so that we go from the first to the second. Potentially, then bringing the jury back here. I would say that we would start witnesses after the second day. So I would tell the state not to be prepared, that we start jury voir dire, and be prepared for opening statements, and then I would break. My guess would be that we could be done on that second day of jury selection of opening statements. You should put on your calendar that we'll be off on October 3rd, that Friday, and then we'll start on that Monday with witnesses in the state's case. So again, jury selection, jury sworn in, done on the first 2 days, opening statements, I would hope to be done on that second day. If we're early, then we're early. If we have to break early, we'll be off on that Friday, and we'll start Monday with the state's case. Is there anything further from the state of Ohio that we want to place on the record before we recess?
Not at this time, Your Honor. Thank you.
And you know, I do ask it every final meeting. Is there any mark on the file as far as the plea offer that's been approved or noted for the file that I need to address with Ms. Ellis at this time?
No, there hasn't, Your Honor. Based on the filing by the defense, that at this time, there obviously are some disputed issues, and so therefore there is no mark on the file.
All right, very good. And then Mr. Mack, anything further for the record?
No, Judge, we haven't requested.
Very good. Anything further regarding trial?
None that I can think of.
Very good. Thanks everyone again for modifying your schedule at this time. All right, we'll adjourn.
So that's what happened. They had jury selection started on the 1st last Wednesday. He said they're going to start Friday, but they didn't. They didn't start openings until this afternoon, today, the 6th of October. It took a little longer than they thought. So we're just going to do the openings and then we're up to speed. That's the recaps. Day 2 tomorrow, guys. Day 2 tomorrow. Where they'll be calling witnesses. Got a bug here. So let's go to the openings. Just got to find it. And the prosecution opens. All right, let's go.
Ladies and gentlemen, that on that day, Bionca Ellis also was having an ordinary day. And you will see through the video that we will show you, ladies and gentlemen, and there are going to be witnesses. Witnesses from Volunteers of America. You will hear from witnesses from Giant Eagle. You will hear witnesses from the police department. For Bionca Ellis, you will see that she went to the police department on that day. She went to the North Olmsted Police Department. She had a conversation with a police officer at the window. And that police officer will come in and testify to their conversation. Bionca Ellis did not like what she heard at the police department, so she leaves. And the evidence is going to show, ladies and gentlemen, that she went directly to Volunteers of America. You will hear the testimony from Diane Spihar, who is one of the managers of Volunteers of America. And on that particular day of June 3rd, 2024, she was working in the back, sifting through stuff to put out for sale. And Bionca Ellis comes back. Well, the evidence is going to show through video that prior to going back to the Volunteers production area, Bionca Ellis had spent several minutes sifting through a bin of knives. And she chose 2 knives. You will see that, ladies and gentlemen. You will see her in Volunteers of America walking up and down the aisle. She had a conversation with Diane Spihar, looking for a bathroom. The evidence is going to show, ladies and gentlemen, that she left Volunteers of America and that she went to Things Outlet. And you will have the opportunity to look at that video. Bionca continued to go into the store she looked around, and you will see the video of that. She didn't chat with anybody, but she leaves. The evidence is going to show, ladies and gentlemen, that as she leaves, there is a cement pillar. And I want you to pay attention, because she takes those two knives and she hits them against the cement pillar to see their pliability. One knife that she had stolen drops to the ground, but she keeps the 12-inch butcher blade knife in her hand. The evidence is going to show, and the video corroborates, that she walks into Giant Eagle. And you will see through the videos, from the customer service angle, you will see inside the store where Margot Woods and Julian are shopping. You will notice, ladies and gentlemen, in the video, Bionca Ellis coming into Giant Eagle, and she's got the 12-inch butcher knife. And she has it right by her side, and she's walking, and she's walking. And you will see in the video, ladies and gentlemen, that Margot had paid for her groceries. She had her hanging basket on her cart, the child in the seat of the cart, walking out, going to load her groceries and go home. I want you to pay attention to the video. As Mrs. Wood is walking out with Julian, and they're actually having a conversation, Miss Ellis passes them going this way, for lack of a better word to describe, she would be going west, and they are coming east. And so therefore, she sees them walking, and she turns immediately around. And she follows them all the way out of the store. And you will see that she is walking in tandem with them. There'll come a point in the video where you will see that she is walking faster, so she passes them, she stops, waits for them to catch up, and follows them completely out of the store. The cameras outside, ladies and gentlemen, pick up that Margot goes down one aisle. Mrs. Wood is going down the aisle where her minivan is parked, and the evidence will show that this defendant is right on her heels, walking right behind her.
She needs to keep still. She's moving away from the mic.
Ladies and gentlemen, the evidence is going to show, the witnesses are going to testify, that they observed Bionca Ellis approach Mrs. Wood and Julian, and she goes and takes the knife and stabs Julian in the face. Miss Woods tries to fight her off. She stabs Mrs. Woods. And there are independent witnesses that were in the parking lot that sees her stand over Julian on the ground and plunge a knife into his back. And those are common, ordinary citizens that were there grocery shopping or going to grocery shop. Of course, screams were heard throughout the parking lot. People are screaming to call 911, and you will hear from Travis Bush, who sees the stabbing. You will hear from Matthew Stroud, who sees the stabbing and tells his wife to call 911. They all run over. You will hear from Cheryl Molaski. She's a nurse. She runs over. She's one of the first people that runs over, and she says that Miss Woods has that baby so tight that there is blood pouring out of that. She tells them, you've got to put him down, and they start concussion. You will hear from Miss McClaskey. You will hear from Miss Craven. They are both nurses. One is a pediatric ICU nurse. She relieves her. They take turns. The police arrive. Meanwhile, the other witnesses are going to testify that after stabbing that child, Miss Ellis, taking her knife that is now clad in red blood, and she walks away. Just walks away very nonchalantly. The police now have surrounded the parking lot, and they tell her to stop. She immediately takes the knife and throws the knife. The same weapon that she used to kill Julian. She's arrested. She is taken into custody. Police officers will come in and they'll testify to their life-saving measures that they tried to use on the child. You will hear from officers that took crime scene photographs. You will hear from officers, drone footage was taken of the area. You will hear from Shayna Gray from the medical examiner's office that'll talk about the trace evidence that was found and DNA. The DNA that matches Bionca Ellis. You will hear from Dr. Elizabeth Mooney, who's the medical examiner, an assistant medical examiner here in Cuyahoga County, who will tell you what the cause and the manner of death is.
All right, we'll pause it there and quickly turn to Florida for the Spencer hearing for convicted killer Jose Soto Escalera. Today, a judge heard final arguments from both the state and the defense before. We're watching opening statements in the toddler fatally stabbed murder trial of Bionca Ellis
Don't you
going
just
on in
hate
Ohio.
that when they
Let's go back
stop
now
right in the
for
middle?
opening statements.
And lastly, ladies and gentlemen, you will hear from Dr. Stephen Nofsinger, who is the state's witness, rebuttal witness for this not guilty by reason of insanity. Ladies and gentlemen, Ms. Pateo and I have the burden of proof. We accept the burden of proof. The charges for you to consider in this case are those of aggravated murder, murder, felonious assault, child endangering, attempted murder of Margot Wood, felonious assault of Margot Wood, tampering with evidence, and theft. Ladies and gentlemen, the state is confident that when you hear all the evidence in this case, and again, I ask you, pay attention to actions and to words. They're very, very important in this case. And when you do that, you will find Bionca Ellis guilty beyond a reasonable doubt for each and every count of this indictment. She knew what she did. She appreciated.
So that was the state's opening. Let's go over to the defense openings. And I hope that he stays still by the mic because she was all over the place. Somebody should have reminded her to stay within a guideline, you know, by the podium, by the mic. My God, that was terrible.
Bionca Ellis is 34 years old. She has no felony convictions. She has suffered from mental illness since the age of 22, diagnosed with schizophrenia. And Bionca has been treated on an outpatient basis at a place called Murders Taylor for almost 10 years. There's been a lot of ups and downs as it relates to her treatment.
Let me know.
You'll hear from her mother, Yolanda Eggleton, and she'll come in and she'll testify the struggles of trying to get Murders Taylor to medicate Bionca. Because Bionca, when she's on her medication versus when she's off her medication, She's two different people. And she pushed hard
Yeah, but
for
whose
Murtis Taylor
fault is
to
over
try to do
medication? I'd
something
like to know.
about
Whose responsibility
Bionca being on
is it?
medication. And Murtis Taylor's response was, she doesn't represent a danger to herself or others, so there's nothing that we could do. She'll tell you how she lost contact with Bionca over the course of 6 to 8 months prior to this incident. And I'll tell you that no one's going to dispute, the evidence will show that she's a mentally ill person. Between January of 2024 up until the date of this incident, June 3rd, 2024,
Yeah, I agree.
Bionca was off of her medication. The medication, the evidence will show, stabilizes her. Bionca received a Social Security check. And what she did with that check was she traveled from the state of Ohio to the state of California. She traveled from the state of California back to Ohio, and then down to Florida, and eventually back to Ohio. During that time frame, there were many occasions where Bionca exhibited mental illness. There were occasions where she would go to a particular location and try to get herself arrested because she's living in a homeless shelter, because she's living on the streets. She's trying to find structure.
So she knew.
I think the evidence will show that
So she knew,
during her
right?
mental illness, she tried to find places of refuge, unsuccessfully. On June 3rd of 2024, this unfortunate tragedy occurs. Just a few days before, Bionca was in the North Olmsted jail.
All right, we'll hear more from the defense in just a minute. Let me bring in our guest for this hour, attorney and former prosecutor Randolph Rice. Welcome back to Court TV Live. I'm Michael Ayala, now back to Ohio, where the toddler stab murder trial is underway. The defendant, Bionca Ellis, is facing multiple charges, including murder and attempted murder in the stabbing death of 3-year-old Julian Wood. Now, he was stabbed in the face and back while his mother was pushing him in a shopping cart in June of last year. His mother was also stabbed, but she survived. Let's go back and hear more from the defense. They reveal more about her background, saying that her mental illness is to blame in its opening statement.
She committed that act.
Yes.
In broad daylight, never trying to conceal the knife. And she doesn't run away. She walks away. Knife in hand. Still carrying the knife.
She walked away. That's like running.
The evidence will show that there was no rational motive for her to have committed this offense. There's evidence will show that there's no relationship between she and the victims in this case. She still has a knife in hand at the time that the police confronts her. And she does drop it. Bionca's brought back to the police station. And eventually, she's interviewed. There's evidence of mental illness that occurred as a result of her responses in that interview. There's evidence that would show that she was irrational at all points of time. During that interview, while in the jail, even when she arrived in the county jail, sitting naked on the floor. Bionca displayed mental illness from the beginning of this incident, for the months prior to this incident, while in the jail. And if by chance you saw her at her arraignment, the evidence will show that even during her arraignment, she was still mentally ill because she was smiling at the arraignment. The evidence will show that she answered the judge in Spanish when being asked questions. The evidence will also show that we had a difficult time communicating with Bionca. So much so that Dr. Sarah West became involved in the case. And she had to make an evaluation of whether or not she was competent to aid in her defense. And because her mental illness was still going on, Dr. West referred her to North Coast Behavioral. North Coast is a place where mentally ill people, they're there to get restored and for other reasons, but for Bionca's purposes, it's for restoration, to get her competent so she can understand this process. So after the competency evaluation, Dr. West was requested to evaluate her for sanity. And the evidence will show that Dr. West did evaluate her for sanity. She looked at all of her prior psychiatric treatment over the many years since she was age 22, her behavior on the day of the incident, and all the other information that she took into consideration after. And Dr. West made a determination that she was insane at the time of the offense. You hear that evidence. But the state has a right to have their own doctor become involved. And Dr. Knopfsinger also made his evaluation, and he made the opposite determination. You'll have to make that determination based on the evidence that's presented in this case. You'll hear from some other doctors that dealt with her while she was at North Coast. And at the end of the day, you will have to make the determination. And I told you in the beginning during jury selection that she acknowledges through her lawyers, whether she testifies or not, that she's responsible for the murder of Julian. She acknowledges through her lawyers that she's responsible for the attempted murder of Margot. There's no running away from that. That's not what this trial is about. The evidence will show, though, that it is obvious that she was insane at the time of the offense. And no matter what your experiences have been, you have to evaluate that information. That's all we're asking you to do. Lastly, I believe that at the conclusion of this case, you will find that Mr. Johnson and I have met our burden of a preponderance.
And there you have it, guys. Now, that was the openings. Tomorrow will be day 2 of the trial. Now, I can't believe it got this far. I just can't believe it. Now, they've had 2 doctors. One says she's insane. The other one disagrees. The state has taken this to trial. Was there any plea deals going on? Was there anything? Because this has just been trotting along until we are here in trial. Now, he says they made her competent. she may be competent by law today, but when she did the crime, she was not competent because she was off her meds. No, it's not our fault that she decided not to take her meds when she can travel all over United States of America. Uh-huh. I don't even know if they were offered a plea deal that was reasonable. They've taken it to trial. This is the thing. Now, she's not guilty by reasonable insanity, okay? Yes, she knows she did it. But if she was incompetent, she didn't know what was going on, how would she know if she did it or not? So, there you have it. She knows she did it. Well, then you couldn't have been that out of your head if you knew you just stabbed 2 people. Okay? Right. So which is it? So this is going to be very interesting. Like I said, I can't believe it's even got to trial. But doctors examined her. They have 2 different opinions. I mean, their doctor could have said, yeah, she's a bit insane, But the illness that she suffers from, is that really insanity? Do you know what I mean? Is that the definition of insanity? No, you didn't take your medication because that can be controlled by medication. Now, the person that lost contact with her, supposed to be her carer, make sure she takes her meds. She says she hadn't seen her for 8 months. She took off and just left. Well, what did you do about it then? What did you do? Could you have done anything? I don't know. Could she? Could she have called the authorities and said, hey, I need a alert out for this woman who is off her meds and she's a danger to herself and others? I don't know. Was that ever done? Listen, these type of people with this mental health issues, they have to be monitored and kept an eye on, and that's the only way they're safe for others to be around, right? I'm not sure. What did he say? Do you remember what he said about the other person when she lost contact? Was she her carer? I'm not sure if they said she was a carer, but she said she lost contact with her for 8 months. No? Yeah. Okay, then. So we're probably going to find out a little bit more in the trial because, listen, there's a lot of other people. Look at Taylor Shabazz, man. She's insane. She lost her mind, but she's competent and she's serving the rest of her life in prison, in Wisconsin prison up there in Green Bay, Wisconsin. Look what she did. Now she crazy, but not crazy enough, obviously, not crazy enough. She said she was supposed to have another trial. I don't know if it's over or is it in October? Might not be over. I didn't hear anything, for her stabbing the guard in the prison, the nurse or something. Yeah, I can't even believe that's going to trial with Shabazz, knowing how she is. But they don't care, so, why should we care about this one? She's no different. She's no different by the sounds of it. It's very hard to deem somebody that they're insane, because I'm sure that the state would have said, yeah, she's definitely insane. We're going to have to like put her away for a minute. Do you know what I mean? Yeah, but they didn't. So that's the thing. Yeah, but what's justice? Put her away in a controlled environment for indefinite? I mean, that's the only option they had, because once she came off her medication, this is how she acts. So she's a danger to anybody. And look at all the trouble she's been in. Whose fault is that she's not on her medication? Not ours. Not that mother and child's fault. Now, this lady, Ellis, I'll call her a lady. I don't know. She can't help what's happening to her mental status. But he said from the age when she was like 22, what happened to her? What happened to her? Did something real bad happen to her? Or she always been like that and was never diagnosed? I don't know, but they just saying it started when she was 22. So somebody take advantage of her. She had something bad happen to her. She had a breakdown, but it seems like suffers with more than that, schizo, right? Yeah. But many people suffer with that illness. Many, and live a good life with medication. No. So they said she was off her meds. So if those medications can't really do anything for it, it can regulate it, because I watch YouTube. And I watch this one girl that suffers with it. But there's many mental illnesses that people live with. They may have a bad day, but who doesn't have a bad day? Who's sane? And you have a crazy day, like you go nuts. Yeah, okay. You need medication? No, you're just having a bad day. So I don't know about this. This is, how much is she faking it? That's what I want to know. How much is she faking it? Because she knows the law a little bit. She knows what to do. She does know how to play it. Okay? But obviously her illness ain't enough to stop this going to trial. It's gone to trial. And we're on day 2 tomorrow. Now the jury has to decide when we get all the evidence, and the mother and the father, or whoever's going to come up on the witness stand, how heartbroken they are. And even if she is found guilty by insanity, okay, it doesn't matter. She's gonna be found guilty, whether insane or not, and she's gonna go away. She's gonna go away for a very, very long time, and she will not be let out. And she may never get out, because they can't fix her. They can't fix her. So, why did they go to trial? Well, they're just going to make sure that she's put away for the rest of her life, And That's all there is to it. I really do think that she's going to be put into a mental health facility for who knows when. You know, just like those two girls they put in the hospital here in Wisconsin when they stabbed their friend, and they were only 12, and they put them in there for 40 years, and that girl didn't die. She got 40 years. Mind you, she's out now. Yes, she's out now. They both are out now on conditions. But the point is, they put her away for 40 years. So this woman should be going away for 40 years. That's all I'm saying, is to protect others and herself. So I just think that that's going to be the outcome. That's going to be the outcome. And if it took a trial to get that outcome, then it took a trial to do it. Because they obviously couldn't put her away for a certain amount of time without this trial. And I'm thinking that might have been the state's motive to make sure that she just get put away in some mental facility for a very long time. And I think that's why they're doing it, if you ask me. What do you think? Yeah, Morgan Geiger. That's right. Yeah. But what I think is the reason the trial, like I just said, is to make sure she does get put away, probably for the rest of her life. Because once you're in, it's very hard to make you sane again, okay? To make you well when you just don't get well from that. Medication is really not going to help you that much. So there you go. Yeah. So I'm just thinking that's probably the motive from the state to take this to trial, to make sure they do get some justice and make sure that this can never happen to another family, because it will. Should do it again. So anyway, guys, so Rubber, you're going to go live at 11? I'll be awake. So that was just a recap. I was just saying that's the recap, give you some ideas. What do you think? Because that's what I think the motive of this trial is. Put her away. Make sure she never gets out. She can't get out. She cannot be trusted to walk the streets. She cannot. She'll do it again. So guys, I'll see you in the next one. See you later. Thanks for stopping by.